Hey guys and gals, this is the Bar Exam and Chill podcast. I'm your host TJ. Today we have a hypo from the California July 2021 bar exam. We're looking at question 4, and let's jump right into the hypo here. Detective Anna was about to subject David, who was lawfully in custody, to interrogation because she had received a tip from an anonymous informant that David was involved in transporting heroin. Detective Anna advised David of his Miranda rights and asked him if he knew anything about heroin shipments. David replied, "I am not sure if I need a lawyer or not." Detective Anna next asked David how he was transporting the heroin. David responded, "If I had anything to do with it, I would use my car." Detective Anna released David from custody when he refused to answer any more questions. Detective Anna then sent a message to all police officers describing David's car, stating that it was believed he was involved in transporting heroin. Later that day, Officer Baker, who had heard Detective Anna's message, saw the car described in the message. Officer Baker decided to follow the car to see if the driver would do anything that could justify stopping the car. When the car ran a red light, Officer Baker stopped the car and ordered the driver, who was in fact David, out of the car. Officer Baker then did a pat-down search of David and found a cell phone in his pocket. Officer Baker turned on the cell phone, saw a text message icon, clicked on the icon, and found a message to David stating, "The heroin is in the trunk, deliver it to the warehouse." Officer Baker then searched the trunk of the car, where he found 30 pounds of heroin. He arrested David and arranged for the car to be taken to the police impound lot for processing. David is charged with transportation of heroin. David moves to suppress, number 1, his statement, "If I had anything to do with it, I would use my car." Number 2, the text message that stated, "The heroin is in the trunk, deliver it to the warehouse." And number 3, the heroin found in the trunk of the car. How should the court rule on each of the motions to suppress? Discuss. So we've got question 1 here. There's kind of a lot of nuance going on in this hypo. We actually see some red herrings. That's pretty common, right? They may give you something that triggers an analysis or a portion of the law that you might want to discuss, but it's not something that you're being asked about, so you're probably not going to get points for it. Here, I don't think that you would want to spend a lot of time analyzing what, under the anonymous informant at the beginning. We have a tip from an anonymous informant that David was involved in transporting heroin. There's law around that, right? They analyze the test for whether you can use an anonymous informant, and an anonymous tip is under the totality of the circumstances, which is, you could really just bullshit anything if you're given a totality of the circumstances test. You just kind of look at all the factors that you're given. But here, I would not spend a lot of time. I would think of that as a red herring. Why? Because it says right after that, Detective Anna, let's see. Oh, I'm sorry. In the first sentence, it says, Detective Anna was about to subject David, who was lawfully in custody, to interrogation. So we don't really have, I don't think, much analysis on the anonymous intent, because it just basically, anytime they give you like somebody did something negligently or somebody did something lawfully, then you're just supposed to assume that is, you can take that at face value. So we've got here, our first statement is, "If I had anything to do with it, I would use my car." So our issue is, did Detective Anna violate David's Miranda rights by continuing to question him after he stated, "I am not sure if I need a lawyer or not"? And our rule here is going to be, under Miranda v. Arizona, a suspect in custodial interrogation must be informed of their right to remain silent and their right to counsel, and that counsel will be appointed if indigent. So this is like, you probably see it on all the dramas. If you're a fan of like police shows or crime dramas, they will say, you have a right to remain silent. Anything you say can and will be used against you in a court of law. And you have the right to an attorney. And if you're so poor that you can't afford one will be appointed for you. That's your Miranda warning. You can waive your rights to a Miranda warning, but it has to be knowing and voluntary. So you have to, if you invoke your right to counsel and it's unambiguous, you say, "Hey, I'm not going to talk to you unless I have a lawyer," then the police cannot continue questioning you. That would be a violation. So if a suspect unequivocally and unambiguously invokes a right to counsel, the questioning has to cease. But Under this Davis versus United States case, an ambiguous or equivocal request for an attorney does not require the police to stop questioning. That's going to be our rule here that we're going to be applying. The test here is whether a reasonable officer under the circumstances would understand the statement to be a request for an attorney. By the way, they define a custodial interrogation, right? Under Miranda, a suspect is in custodial interrogation must be informed of their right to remain silent. They must be given their Miranda warning. Well, what is a custodial interrogation? They define that as just basically if you don't think you can leave, if you're under circumstances such that a reasonable person would not feel like they have freedom to just walk away from the police officer, then you may be in a custodial interrogation. That's sort of how that's defined. That's how you define that for the bar exam. There is a distinction that we're going to be worried about here as far as the rule goes for if you get statements in violation of Miranda. We kind of laid out our rule here, but statements obtained in violation of Miranda are generally inadmissible in the prosecution's case in chief, but may be used for impeachment if voluntary. And by the way, the key distinction here is the fruit of the poisonous tree doctrine. So under the fruit of the poisonous tree doctrine, if police get evidence and they obtain it illegally or in violation of your constitutional rights to due process, then they can't use subsequent evidence that they find as a result of that violation in court. But if there's violation of a Miranda, which they don't give you Miranda warnings, and then they subsequently get physical evidence, the statement will be suppressed, but the physical fruits will not be suppressed. That's a distinction for under the Miranda rights here. So if you actually get if you're actually obtaining evidence in violation of your constitutional rights, not Miranda, but they violated the Fourth Amendment of the search and seizure rule, then subsequent evidence that they obtain as a result of violating those constitutional rights cannot be used in court, right? That's the fruit of the poisonous tree doctrine. But there is this distinction in the Miranda field. If you get a statement in violation of Miranda, they don't, they fuck up your rights and the reading your rights. Or for instance, in this one, if he had invoked his right to an attorney and it had been totally unambiguous, he said, hey, I need to talk to an attorney and I don't want to talk to you. And they fucked up and they kept asking him questions and they found evidence. The statements that he made to the police officer would be suppressed, but the actual physical fruits of it would not be suppressed. They would be admissible. That's the key distinction in the rule that we're going to be going over here. So let's go through that analysis. We've got custody and interrogation. Here it just gives us directly David was lawfully in custody. And Detective Anna was asking direct questions about heroin shipments, which constitutes express questioning likely to elicit an incriminating response. So Miranda is going to apply. That's our key takeaway here. As we apply it to the facts, Miranda applies. The statement that David made was, I am not sure if I need a lawyer or not. That is almost certainly equivocal. It kind of matches up with the language in that court case. If you're sort of waffling about it, then the police can continue questioning you, basically. You have to unambiguously invoke your right to an attorney for them to have to cease questioning you in a custodial interrogation. So the Supreme Court has held that phrases like, maybe I should talk to a lawyer, are not sufficiently clear to trigger the requirement that questioning cease. So officers are not legally required to clarify ambiguous statements. That's kind of key. They don't have to ask you a follow-up question. For instance, here, David's like, well, I don't know if I really need a lawyer. The officer doesn't have to follow up and be like, well, I mean, are you sure you don't want a lawyer? Right? They can just continue asking. So that's kind of what Anna did here. She just continues asking about him transporting heroin. And he didn't invoke properly his right to counsel. So that's going to be our conclusion here. The court should deny the motion to suppress. The statement was made following a valid Miranda waiver. He answered voluntarily and without an unambiguous invocation of counsel. So those statements are going to come in on the facts that we have in this part of the hypo. Let's go to question 2. We've got a motion to suppress the text message. The text message was reading, the heroin is in the trunk. Deliver it to the warehouse. So our issue is, was the warrantless search of David's cell phone incident to a lawful arrest or justified by another exception to the warrant requirement? So if you're going to search somebody's cell phone, you're going to need probable cause and a warrant, right? The Fourth Amendment protects against unreasonable searches and seizures. There's your bright line rule here. A search conducted without a warrant is per se unreasonable unless it falls under an exception, which one of them is the search incident to lawful arrest. This allows police to search a person in their immediate wingspan following an arrest. So let's kind of talk just generally about a search incident to a lawful arrest. The search incident to a lawful arrest exception allows police to perform a warrantless search provided there is a lawful custodial arrest. The requirements are a lawful arrest. The arrest must be made based on probable cause. If the arrest is unlawful, the search is unconstitutional. Boom. Also, the search has to be contemporaneous. What does that mean? Well, it's got to be going on right when the arresting's going on. It can't be like at a later time or whatever. Search has to take place at the same time as or immediately following the arrest. Has to be contemporaneous. What's the scope of a search that you can do under SILA, the search incident to a lawful arrest? Well, the police can search the arrestee's person, including pockets and containers found on the person, except for cell phones. So this is going to be our exception here. It's within the grab area. That's, I think, how the case law defines it. It's within your wingspan. So police can search areas within the arrestee's immediate control where they might reach for a weapon or destroy evidence. That's your scope of your search here for a search incident to a lawful arrest. You can't like search way outside that wingspan, basically. They just want to make sure that the police can, be safe and make sure you don't destroy evidence is kind of the logic behind that. There is a special rule for automobiles. If the arrestee was an occupant of a vehicle, right, police can search the passenger compartment only if there's an unsecured arrestee, meaning the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search. He's unsecured, right? So he's not like with, his hands handcuffed behind his back somewhere, pulled out, somewhere like outside the car. Then it's not going to be good. So you also have to have evidence of a crime. It's reasonable to believe the vehicle contains evidence of the offense of the arrest. So it has to be whatever the probable cause was to make the initial arrest. It has to be reasonable to believe that the vehicle contains evidence of the offense of the arrest. So if you're arrested for a taillight violation, police can't search the car for drugs under the search incident to a lawful arrest because there's no evidence of drugs, right? If it's just a broken taillight, maybe the officer would have to see something in the car like paraphernalia, a pipe, maybe like loose marijuana. They'd have to be probable cause to actually search like for drugs in the car. Those are kind of our rules here. What are the requirements? Well, again, you got to have a lawful arrest. So if it's a lawful arrest, it's got to be based on probable cause. If the arrest is unlawful, the search is unconstitutional, and it's got to be contemporaneous. So let's get into the analysis here and the application to our facts. Officer Baker had probable cause to stop David because he ran a red light. There was a traffic violation. That's going to give him probable cause to make a stop, right? A pat down for weapons. This is called a Terry frisk. This is allowed if there is reasonable suspicion the person is armed and dangerous. So if the police has any reason, and reasonable suspicion is a lower bar than probable cause, police officers honestly can just justify this basically with anything, right? They just have to articulate something that made them suspicious that you may be armed and dangerous. Maybe they see a bulge somewhere, right? That's probably all they need. And they probably just have to say that they saw a bulge somewhere. I mean, the reality is the police are going to be able to say kind of whatever they want, unfortunately, to justify the reasonable suspicion. Probable cause is a higher bar. So here it's debatable if Baker had such suspicion, but even if the pat down was valid, the search of the contents of the phone is not going to be valid. So the phone search, there's this case called Riley, right? Even if David were under arrest at that moment, Officer Baker could not search your phone's digital data without a warrant. He would need probable cause and to go to a judge to get them to sign off on a warrant. Why? I mean, I feel like it's a little bit obvious. You have so much private information in your smartphone these days that the court is not going to just allow the police officers to check anyone's phone. That's a pretty invasive search. So they're going to want probable cause and a warrant in order to get into your cell phone. Here, right? I mean, and by the way, what are the exceptions to the warrant requirement? exigent circumstances. So if there's some kind of emergency, right, and it has to be a pretty serious emergency, the phone is right about to explode, or you got to get in there, or like they're just gonna kill somebody unless you check a text message and you know for sure that this is all gonna happen. You have to justify it with some kind of super emergency situation. Here we don't have that going on, right? I mean, he just opens the phone and sees a text message and opens it. By opening the text message here, and he saw that icon in the fax, and he just opens it. Officer Baker is exceeding the scope of any warrantless search exception. So they could try and use this search incident to a lawful arrest, and that would be like anything in your wingspan. And they could probably, the police are going to argue, right? Hey, it's within his grab area. That's the key phrase here. The phone was in his grab area, so we could search the phone, right? That's not going to be correct. If you want to get into a smartphone, you're going to need probable cause and a warrant, because it's super invasive to get into somebody's cell phone. So our conclusion here is the court should grant the motion to suppress with regards to the text message. The search of the cell phone was a warrantless search of digital data in violation of the Fourth Amendment. All right, nice. We're moving right along here. We've got this question 3. We've got a motion to suppress the heroin. So the cop finds 30 pounds of heroin in the trunk of the car. So our issue here is going to be, is the heroin admissible under the automobile exception, or must it be suppressed as fruit of the poisonous tree? So what is this automobile exception, right? You've got like these exceptions to the warrant requirement. Automobile exception, police may search a vehicle without a warrant if they have probable cause to believe it contains contraband. This search can extend to any part of the vehicle as long as you've got probable cause. So let's kind of delve into this. This automobile exception, I guess it may be called the Carroll Doctrine. It allows search of the entire vehicle, which would be anything like the compartments in the car, the trunk, but it has to be triggered by probable cause. The officer must have probable cause to believe that the vehicle contains contraband or evidence of a crime. The scope of it, again, if they have that probable cause, they can search anywhere in the car, the glove box, consoles, the trunk, any containers like purses, suitcases, backpacks, and they can hold the item. But the key distinction here is you don't need to be under arrest for this to apply. The mobility of the cars on the side of the road is what justifies skipping the warrant, but you have to have probable cause. So we've also got this fruit of the poisonous tree doctrine, right? Evidence derived from an illegal search or seizure is generally inadmissible. So let's apply this to our facts here. Well, probable cause. Before searching the trunk, Officer Baker the only new information he had was the illegal text message, which we've established in question 2. That's going to be unconstitutional. So the heroin in the trunk, he probably did, right? I mean, there's the text message is giving him some sort of information that there's heroin back there, but we're saying he was not constitutionally allowed to just open the phone and start searching through it. So here, as opposed to, the physical evidence in violation of the Miranda doctrine, there's actually a constitutional violation. He got the search through a text message. So that's going to be the key distinction here. The only way he knew that there was heroin back there was as a result of this illegally obtained text message that he looked at. So we kind of want to look at the police could try and argue, hey, we would have found it anyway, right? I mean, this is one of the other exceptions here. If it was inevitable that they would have found it, and even disregarding the constitutional violation, then they can justify it as admissible. So we kind of want to look at what does Baker know other than this text message? Well, he got, number 1, Detective Anna's tip that the car was believed to be involved in heroin, and number 2, David's earlier statement about using his car, right? We have that statement up there. What did he say exactly? Let's go up. If I had anything to do with it, I would have used my car. That was told to Officer Anna, and she got on the message and kind of relayed this to the other officers. So the Officer Baker is going to want to argue that, look, it was inevitable that we were going to find this heroin in the trunk of the car. Therefore, it should be allowed as admissible. And the opposite side, on the other hand, you've got the guy with the heroin. He's going to argue that, no, this was actually fruit of the poisonous tree doctrine. So you've got a couple different arguments to dissect here. it may be that you come down. It feels like the conclusion here is not like the most important thing. As long as you're following the analysis here, it seems like you're going to get points, and then you sort of just make your judgment call here. Your judgment call here. Here, we're really analyzing for the sufficiency of the evidence that he had outside that text message. Would that lead him to the heroin in the trunk? So we've got an anonymous tip from Anna's source plus a vague kind of hypothetical statement. If I did, I'd use my car. Ooh, I mean, it kind of sounds like he might have heroin in the car, but he's saying if I did, not I definitely did this and it's in my car. So likely this may not rise to the level of probable cause. I mean, this is going to be reasonable suspicion, right? I don't know. The officer is going to argue that this gave him probable cause to search the car. It seems like it may give him probable cause, but also, you have a vagary around an anonymous tip, totality of the circumstances. It has to one of the things that they analyze is this predicting future behavior? How reliable? There have to be these indicia of reliability is how they analyze for whether there's probable cause or not if there's a anonymous tip. The search of the trunk was directly prompted by the illegal reading of the text message, really. So here, since the text message was the poisonous tree and the discovery of the heroin was the fruit, it's likely that the fruit, the heroin is going to be tainted. Now, again, the officers are going to argue that this was an inevitable discovery. Prosecution might argue that the car would have been impounded and searched anyway. So you also have what's called this inventory search. This is kind of interesting, but if you get arrested and your car is on the highway or it's somewhere where it's illegally parked, you can't just park there, then if there's nobody to drive your car away, then it's going to get impounded. And as a result of that, I think the requirement here is police officers, the police office, they have to have a routine actual policy for when you impound the car, an inventory search will be conducted and how, basically outlines it. And if they do have some kind of a policy like that that's outlined, if they impound your car, they can conduct an inventory search. So the prosecutor might argue here that, hey, the car would have been impounded anyway if he was pulled off to the side of a highway. If he's parked in front of his house or he's somewhere where his car can just be left, the police can't just impound a car because they want to search it. That's the whole distinction here. If the police are going to try and impound the car just so they can search it, that's not going to be good. The car, there has to be some reason why the car is getting impounded, and then it has to follow some procedure that the police have outlined already. They have to have a policy in place dictating how the inventory search is done. Here, we don't have any facts for that. So since the car was only impounded because of the heroin being found during the illegal search, it's likely here that the argument from the police officer's side would fail. But I think that there is, like we said, this goes back and forth on this one. It seems to me that the bar may want the court to grant the motion to suppress here because it's the fruit of the poisonous tree doctrine, but we've got these exceptions, and I think there's a justifiable argument to make if you wanted to say on your conclusion, hey, I think the court would deny the motion to suppress because there's this inevitable discovery doctrine. The car probably would have been impounded and searched anyway, or he has the anonymous tip from Anna. She sent out this radio wave, and he made a statement basically saying, hey, if I had heroin, I'd probably be using my car. It's pretty close. I mean, it may be that it was inevitable. So I think the conclusion is a little bit less important on this one. You can kind of see that I don't think it really matters. A judge could go either way, right? That's kind of what these bar exam hypos are about. A lot of times in the law, it's not clean. It's going to depend on who your judge is, to be honest. So if it's up in the air, I don't think the conclusion is necessarily the most important part. As long as you're going through these factors under the analysis and you're doing your best to get the law on the books on the page and analyzing under those rubrics, then you're going to do fine. You just have to kind of have all these laws and apply them to the facts as we have them. So we've kind of gone through them here. Let's see. And I think I would come down on the court should grant the motion to suppress. Again, the heroin is fruit of the poisonous tree resulting from the illegal cell phone search. That's how I would argue it. And the officers lacked independent probable cause to search the trunk at the time of the stop. That's the key point, I think, is from my perspective, it doesn't rise to actual probable cause here. There's some vagary statements like, well, if I was going to do heroin, I guess I would use my car or whatever. I don't think that's going to give you probable cause to search the trunk. It's not like, hey, there's definitely some heroin back there. It's probably worth noting that, you want on these Fourth and Fifth Amendment and Sixth Amendment sort of questions or whatever, it's good to remember that the Fourth Amendment applies to the states via the 14th Amendment. That's the incorporation doctrine. That's usually stated like at the beginning of these essays. That's one of those like canned statements that you want to have memorized for the bar. If you get one of these, you're going to say, hey, this is, unreasonable search and seizure under the Fourth Amendment. It applies to the states via the 14th Amendment. Boom, that's an easy point. So if you have that memorized, you can just throw that in. You shouldn't have to think about it. That's an easy point for the bar exam. This is all a little bit tricky, right? So I just want to go and kind of review and come up with a little bit of an attack plan here and go through this a little bit clearer, I think, than maybe was made in the hypos. So if I want to just talk about a Terry stop and a frisk and a search incident to a lawful arrest, let's go through those standards so it's a little bit clearer. For a Terry stop, you only need reasonable suspicion to conduct a Terry stop. That's like the stop and frisk policy. You do not need probable cause. Anything that the officer can articulate, and it's basically anything. Like if the police officer says that they had a reasonable suspicion, all they have to do is articulate any reason why. You looked fishy, I have experience on the job, and he was nervous looking around or whatever. They can pretty much say anything they want. That bar is going to be super low. For a stop and frisk, the officer just has to have reasonable suspicion. For a search incident to a lawful arrest, well, first of all, you have to have a lawful arrest, which means you have to have probable cause. If you're getting arrested, the officer needs to have probable cause to do that. So just for the justification, there's a difference between a stop and frisk and a search incident to a lawful arrest right there. That's good to know. Search scope, right? Under the Terry stop, they can basically do a pat down. And if like, this is where if you have like a weapon or a bulge, they're only checking for a weapon, because if you're doing a Terry stop, basically they just want to protect the officer and make sure that somebody's not going to like kill them or whatever. So you can kind of like pat outer clothing, and you're not, if you feel something in the clothing that is resembling of a weapon specifically, or like, for sure it's some illegal substance of some kind, you can tell through the jacket, then they can get in there and search it. But for a search incident to a lawful arrest, it's a little bit broader. It's not only like your full body. If it's a search incident to a lawful arrest, it's also what they call this grab area. And again, that's your key phrase. Search incident to a lawful arrest, anything that the person can grab at, which if you're in a car and you're in the driver's seat of the car, that's pretty the most common. You can get into the glove compartment. You can just reach over and just pop that open. So for a search incident to a lawful arrest in the grab area, if it's in the glove compartment area and you're in your there's probable cause and you're being arrested, the cop can get in there and look, basically. So it's good to know that. The evidence for a Terry stop or a Terry frisk, stop and frisk, it has to be immediately apparent. Right? It's got to be like, hey, there's really like a bulging gun in your jacket or whatever. If it's a search incident to a lawful arrest, you can basically just kind of look for anything, right, in the grab area, as long as it fits within that probable cause. So we've got our bar exam attack plan here. You're going to analyze the initial contact. Did the officer have reasonable suspicion where they could do a stop and frisk under this Terry stop standard, or did they have probable cause, in which case they could make an arrest and a search incident to a lawful arrest? You want to check for the move. Did the officer go beyond a pat down? If they reached into a pocket without plain feel, the evidence is going to be suppressed unless it was a search incident to a lawful arrest. So that's where that importance between reasonable suspicion and probable cause comes in. This is also tested really heavily on the MBE, so knowing these distinctions is really important. Can you check the trunk, right? Again, let's just kind of review. If it's it's neither a search incident to a lawful arrest nor a Terry stop is going to allow for a search of the trunk. You need independent probable cause to get back there, because that's not within your grab area. If you're, that's kind of what we're saying here. For stop and frisk, you can really just get the jacket, like anything that's outer clothing. If you can articulate, hey, there's looks like a weapon in there, then okay, you can kind of search around in there. But for a search incident to a lawful arrest, again, you're limited to this grab area. Can you grab in the trunk? No, you'd have to get out of your car, pop the trunk, get in there. So in order for the police to get into the trunk, they're going to need some independent probable cause. You do have the automobile exception, but again, there has to be independent probable cause to conduct a search of the entire vehicle. We kind of went over that. And we have this exclusionary rule, all right? If you have evidence that's obtained on a violation of the Fourth Amendment or your constitutional rights, then you got the fruit of the poisonous tree doctrine, and that can be suppressed. But we have this distinction, right, within the first question. If it's a violation of Miranda, like you didn't properly invoke your right to an attorney or whatever, then the statements that you made that are incriminating, those will get suppressed. But physical evidence that they got as a result of that is not going to be suppressed. So there's a distinction there. We've gone through this whole hypo. It's a little bit confusing in this criminal law stuff, but hopefully we've clarified it a little bit for you. I think looking at these situations and specifically what's going on here and how do you analyze it, it can help to flesh out what is all the nuances and distinctions here. And I think we've got a good jump on this criminal law and criminal procedure. If you have any questions, get at me. You can email me at the barexamandchill@gmail.com. But I'm on Reddit as well. I'm on the social medias. Leave a comment on YouTube, I guess. So we've got a YouTube channel. So if you have actual questions, I'm happy to try and address them and clarify anything that you may want further information about. And that's all we got for today. Good luck, guys. Happy studying.